Hi, everybody. Something extraordinary happened today, and I want to talk about it. Uh, a draft opinion from the United States Supreme Court was leaked. An employee of the Supreme Court must have leaked it to the press. And this is something I have never seen happen before. So that is very, very surprising. And the opinion that was leaked is probably the most important opinion of this term, and may be the most important opinion for a while. It is Dobbs versus Jackson Women's Health Organization. And this is the opinion about the right to abortion in the United States. Two cases, Roe versus Wade and Planned Parenthood versus Casey, starting in 1973 and then in the 1980s, had established and then clarified what the right to abortion is. And was a fear, seemingly realized, that those cases were going to be overruled. So we've got a first draft of an opinion by Justice Alito in a case that will probably be decision issued in June or so, but we kind of know what's going to happen. And this opinion, by the way, I think is legitimate. I've read it. It seems like a legitimate opinion. It doesn't seem like it's just been made up. So this is probably the real thing. Now, of course, because it's a first draft, it's subject to change, but it's unlikely to change in its structure, in its reasoning. Maybe details will change here or there, but this is pretty much what we can guess the final opinion is going to be like in June. So I want to spend the rest of this video explaining to you what this opinion does and what its reasoning is. And I want to do that because I think it's hard for people to read these long opinions. This one's with its appendices like 80 or 90 pages. And I think that I can give you its essence in 10 minutes, 15 minutes. And then you don't have to trust me. You can go and read the opinion yourself or check what I have to say against the opinion. Okay? So let's start with what this opinion does. Justice Alito's opinion holds three different things. And I apologize, I'm going to have to look at my notes from time to time in speaking with you. First, it holds that the United States Constitution does not confer a right to an abortion. And consequently, it overrules both Roe versus Wade and Planned Parenthood versus Casey. And the result of that is it returns the authority to regulate abortion to the political process. It takes the issue out of the courts and gives it to the politicians. Now, maybe a nicer way of saying it gives it back to the voters. So, in short, there's no longer going to be a constitutionally protected right to abortion in the United States, at least under the United States Constitution. Now, state constitutions in some states might be interpreted to protect the right to abortion, and states themselves can certainly pass laws that protect the right to an abortion. But no longer will the decision be given to those judges who are interpreting the United States Constitution. Okay, so let's talk about the result of this opinion. And there's a lesson here for when you're reading opinions from any court. The first pages of the opinion are the ones that are likely to be read and read by the press. So those pages are going to be the easiest to understand and are going to give sort of high-level points that can be easily presented to the people through the journalists. But it's at the end of the opinion, usually the last two sections or so, where a lot of the most important stuff is. So the last large part of this opinion concerns the test that the court will apply now when it comes to any regulation involving abortion. And what the court does is establish a rational basis standard. Now, this is a standard that courts use when they're looking at any form of legislation. All legislation has to be minimally rational. It can't be, it can be stupid. It just can't be crazy. Okay? So the test has two parts to it. First, the courts look to find what the purposes are that are being asserted for the legislation. So all legislation is for some reason, right? There's legislation against murder to prevent people from killing one another, okay? Because that's bad. And the state has an interest, a purpose in protecting its people from being killed, right? So the first question that the court asks is there a legitimate state interest? And then the second question that the court asks is the statute itself rationally related to that legitimate state interest? If those two things are true, then the statute is constitutional. So the way to think of this is if the statute is completely irrational, then it's going to be unconstitutional. But if there is minimal rationality, then the statute is going to be constitutional. Now, that's a very easy test to meet. So almost any regulation of abortion is likely to be constitutional. Now, the opinion goes beyond that, and in what I think is the most important paragraph of this entire opinion, which is at page 66, Justice Alito tells us 5 legitimate state interests. He just says these interests are all legitimate. And in that paragraph, he gives justification for essentially any regulation of abortion, at least in my opinion. So let me go over those 5 legitimate state interests with you. And I'm just going to highlight a few for you. So the first one is respect for and preservation of prenatal life at all stages of development. The state, the government, has a legitimate interest in preserving the life of prenatal beings, fetuses, unborn children, at all stages of development. Now, it seems to me he's saying that at the moment of conception, that's the beginning of prenatal life. And the state has a legitimate interest in preserving that life from that moment. Now, he doesn't say that life begins at conception, but that's how I read the words at all stages of development. You may disagree with me, but it seems like a rational reading, doesn't it? So what does that mean? Well, at the very beginnings of life, from this perspective, we have a lot of techniques that we kind of consider to be contraception, but might be ruled to be abortions and could be regulated by the government. As examples, the morning after pill. So the morning after pill is effective when, conception has occurred or after conception has occurred. Likewise, there are hormonal IUDs that prevent a fertilized egg from implanting onto the uterus. That happens after conception. So those forms of contraception / abortion may be regulated by some states. We'll see what happens. Now, that's important, but what I think is more important is this. The rational basis test is not a balancing test. It doesn't weigh various factors. It, as long as there is one legitimate state interest, that's all that the legislature needs in order to regulate. So that means that things like the health and life of the mother, the state doesn't have to consider that. Likewise, whether the, the pregnancy is due to incest or rape, the state doesn't have to consider that either. As long as there's the legitimate state interest in protecting the life of the unborn child or the fetus, that's enough. Okay? So this particular test does not require any weighing or balancing or any consideration of what the mother is going through, or the pregnant woman is going through. It only has to consider the life of the child or the fetus as a legitimate state interest. Okay, so that's legitimate state interest number one. Number two, the elimination of particularly gruesome or barbaric medical procedures. Now, it seems like this state interest in avoiding gruesome or barbaric medical procedures is really aimed at one form of abortion procedure, which is the dilation and evacuation procedure, usually done later in the pregnancy of a woman. But I've got some concerns about this in how it might be applied in other circumstances. So I don't know how you define a gruesome or barbaric medical procedure. To my mind, almost any invasive medical procedure is gruesome, and barbarism is, in my mind, impossible to define. But I've got some worry that this will apply, or at least some legislatures will attempt to use this language to apply to sex reassignment surgery for transgender individuals. My fear may not be realized, but just the fact that they have said that gruesome and barbaric medical procedures are something, are legitimate state interest, it's legitimate for the state to want to prevent those, makes me feel like some state legislators will try to say that sex reassignment surgery is in fact gruesome and barbaric. I hope that's not realized. Other legitimate state interests include the preservation of the integrity of the medical profession, the mitigation of fetal pain, and the prevention of discrimination on the basis of race, sex, or disability. Let me say a word about that. There are laws that some states have passed attempting to prevent people from getting abortions to favor one gender over the other. That is, to get an abortion because the parents want a boy rather than a girl, or for other gender-related reasons. Likewise, some parents might not want to have a disabled child, but the state has an interest in the life of that child, according to Justice Alito. Now, those to me seem to be not offensive, but my concern is when it comes to very, very serious disabilities, and when it comes to fetuses that are unlikely to survive the experience of birth or much past birth. That is, are we going to force women, through legislation, to bear a child who is likely to die within the first week or 2 weeks of life? Okay, so now what effect does this have on other areas beyond abortion? Justice Alito says it's not going to have an effect. We'll see. But he explicitly says this. He says, to ensure that our decision is not misunderstood or mischaracterized, we emphasize that our decision concerns the constitutional right to abortion and no other right. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. Okay, that's reassuring, but my concern is that there's not a very clear line between contraception and abortion, and that this may have effects on the right to contraception as well. Okay, so let's talk about the reasoning of this opinion briefly. Much of the opinion is devoted to two subjects that I don't want to talk about. First, the opinion criticizes at great length both Roe versus Wade and Planned Parenthood versus Casey. We won't discuss that. Second of all, it goes into great detail about the doctrine of stare decisis, which simply means that the Supreme Court should follow its own decisions from the past. And in this case, the Supreme Court is not doing so. So it justifies that, saying that the doctrine of stare decisis does not apply in this instance. So instead, I want to focus on the right, the liberty interest that a woman has in her own decision making with regard to whether to give birth or not. Okay. Now, there are tests for liberty interests. We know that the Constitution lists a whole bunch of different liberties in the Bill of Rights. And then there are some additional liberties that are scattered through the Constitution. But there are also liberties that the Constitution protects that are not explicitly stated in the Constitution. And in fact, the Constitution assumes that there are going to be rights that the Constitution itself does not explicitly state. So the Ninth Amendment to the Constitution says the following: the enumeration, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So there are rights that are retained by the people that are not listed in the Constitution. But what are those rights? Well, there are some tests that the United States Supreme Court has come up with. And all of the justices of the Supreme Court agree what the test is, but different justices emphasize different parts of the test. So the test is, you can refer to it in different ways, as the substantive due process test or the fundamental rights test. But it comes down to this: rights are much more likely to be protected if they are fundamental, and fundamental rights are determined by a particular test that judges have created. That is, if the right is deeply rooted in the nation's history and tradition, then it's going to be a fundamental right. Likewise, if the right is necessary to the concept of ordered liberty, it's going to be a fundamental right. Now, that last phrase, necessary to the concept of ordered liberty, is very, very difficult to define. So, what does Justice Alito say? He says that the right to abortion is not deeply rooted in this nation's history and tradition. Quite to the contrary, the nation's history has been to forbid abortion up to the time that Roe versus Wade was decided. It's true that some states were liberalizing their laws, allowing for abortions in certain contexts. But for the most part, states continued to forbid abortion up until Roe versus Wade. So he says this right is not deeply rooted in the nation's history and tradition. And then he talks about necessary to the concept of ordered liberty. And he says that the right to abortion, while certainly a liberty, is not part of ordered liberty. That liberty itself has to be in some form of, has to have some form of order. And that if we were to say that there is a right to abortion, why is there not a right to, use drugs, illegal drugs, or engage in prostitution or hire prostitutes? There has to be some form of ordering. And the right to abortion does not fit within this concept of ordered liberty. Now, the reasoning is, I think, perfectly rational. I don't think that there's anything wrong with the way that he's reasoning, but you should also know something else. There's already a pre-existing right that some call the right to privacy, but I prefer to think of as the right to be left alone by the government. And this right has been recognized for a long time, 100 years, and has been elucidated in a variety of different contexts. So, for example, the government doesn't have a right to tell me who I live with and who I don't live with. It doesn't have a right to tell me who I sleep with, who I have sex with. It doesn't have a right to tell me who I can marry and not marry within reason. And it doesn't have a right to tell me how, whether I'm going to use contraception or not, and how I'm going to raise and educate my child. I can choose to educate my child in a private school or educate my child myself, right? All of those rights are protected under this umbrella right to privacy. And the word privacy, I don't like it because it suggests some form of informational privacy, but this is really about decision making, your ability to decide things without government interference. Okay, now, Justice Alito, at least impliedly, deals with the right to privacy. He says that all the examples of right to privacy have nothing to do with abortion except for Roe versus Wade and Planned Parenthood versus Casey. So those other cases are not analogous. Contraception is not analogous to abortion. Gay marriage is not analogous to abortion. Interracial marriage is not analogous to abortion, etc. And then he says that all those other cases are very different from our situation because all those other cases do not involve the destruction of a potential life, while this case, an abortion case, deals with exactly that. Okay. Now, I think that there's an answer that at least liberals will likely agree with, though of course conservatives will not, to what Justice Alito has written. I think it's the following. Justice Alito defines the right here as the right to abortion. But that's not really how women who are seeking an abortion conceive of this right. Right? The right to abortion is simply a means to some broader right. And that's the right to control one's own body without the interference of the government. Now, when you think of it that way, then some of these other cases are much more analogous. So, for example, cases that say that laws forbidding sodomy are unconstitutional, Lawrence versus Texas. That's about a person's ability to control their own body, right? Cases about contraception. That's about a person's ability to control their own body. If you define the right that way, then it does seem like there's a constitutional issue that has to be resolved by the courts. Okay, I hope that helped you understand what this case is all about. The takeaway from this is that the courts, at least the courts that are going to be interpreting the United States Constitution, are getting out of the business of saying whether an abortion law is constitutional or not, which means that this all becomes a matter for the political process. And you could imagine, theoretically, a state passing a law that says that abortion shall be legal in all cases up to the moment before a live birth, theoretically. You could also imagine, theoretically, another state saying that abortions are illegal in all circumstances from the moment of conception forward, regardless of the life and health of the mother. Theoretically, you could imagine that. And every option in between those two extremes is allowable as well. It all comes down to the political process and what the politicians decide. And of course, we decide who those politicians are going to be. The takeaway from this video is that it's now in your hands. It's not for me. It's not for any other lawyer. It's for we, the people, to make the decision about what we are going to be in the years to come. Thank you for listening. I'm so glad that you stayed with me. Bye-bye.